The crime says, hit the like.
Greetings and welcome to Assignments, Form and Requisites from American Jurisprudence. Before we get started, just to remind everyone, this is strictly for the educational entertainment purposes of this YouTube channel and broadcast, not to be used, misconstrued, or abused for anything legal, lawful, personal, public, private, financial, business, tax, or otherwise. Please don't do this at home. That said, let's get started. So what we're going to be going over is first just briefly the partial assignments, and then we'll go over the form and requisites, consideration, delivery and transfer, intent to assign, and then finally the filing, recording, and notice of assignment. So let's start with the partial assignments. Pay attention to this. This goes by quick, but this is essential. So Section 79, generally, under the common law, an entire claim or debt arising out of a single transaction cannot be split up by an assignment and be the subject of several suits, absent, of course, the debtor's consent or the equitable joinder of all parties holding an interest in the debt, since the debtor should not be subjected to multiple suits or claims not contemplated by the original assigned contract. So we have a debtor and someone that's assigned role here. So you have under common law the entire debt. So a creditor assigning that, or a debtor without the debtor's consent, or an equitable joinder. So there'd be some expectation of some other party having a assignment perhaps. But let's look here. Thus, for example, when a cause of action has accrued, the holder of that cause may not assign the right to recover part of the damages available under the claim while retaining the right to cover the balance of damages to himself or herself. So this is like a attorney saying, keep part and then I get the rest, or something where they can only work to get partial recovery on one claim, leaving the balance for another claim. There'd be multiple claims. The question for the court in deciding whether a partial assignment has taken place is whether it was contemplated that there would actually be an outright assignment of some right, interest, and authority to control of the claim, or only a promise to pay out any proceeds of the claim that might be collected in the future. So here's our key distinction. Outright assignment of right, interest, or control versus a mere promise to pay from future proceeds. So unless it's the entire claim or debt arising out of a single transaction, that would have to be the assignment. If it's just a mere promise to pay from future proceeds, like out of a settlement here, partial payment, there is partial assignment is not cannot be split. So there it is. Let's move along. Unless, of course, it's been agreed upon by the parties. So there can be a, you could say a partial assignment if it's agreed upon per the terms of the contract. So let's look here generally on this with a practice tip. A partial assignment in and of itself does not bar all recoveries on one cause of action. Only the second recovery is barred. So just because there's a partial assignment doesn't mean that that first recovery doesn't have a cause of action. It's just if you try to come with the second one, it's barred because the first one's already been settled. But there's a caution. The original debtor's right to defend against a partial assignee is not affected by the notice of the partial assignment. So notice is not necessary. So the debtor's right to defend is not affected by notice of the partial assignment. So let's look here. The first recovery is allowed. Second recovery, of course, would be barred. The debtor's defenses are unaffected by notice. All right, so we're on to Section 80, the obligor's waiver or consent. So the one that's making the promise here or such, the right to raise an objection to a partial assignment may be waived by the debtor. Here's our practice tip. The debtor's objection to a partial assignment of a debt may be asserted by the rejection of the claim and an absence of proof of consent or a showing of hardship on part of the debtor in complying with the partial assignment. So here's our objections. Wow, this is interesting here. So there's a right to raise an objection which may be waived. So the debtor's objection to the partial assignment may be asserted by the rejection of the claim, rejecting the claim, and an absence of proof of consent. So that may be asserted by, this is and an absence, or a showing of hardship on the debtor in complying with the partial assignment. So this is probably where the equitable portion comes in. So there's three ways to object: rejection of the claim, absence of proof of consent, or showing of hardship. So three ways to object to a partial assignment. And as for the debtor, or the obligors in this case, as you could say, the obligor is the one making the promise. So the debtor is making a promise to pay, so to speak. Let's move along. So we have Section 81, the partial assignment of wages. We know this is not favored by the courts, but an inaction to recover wages for services already performed under a single indivisible contract. The entire amount due at the time of the suit is commenced must be sued for, although claims for services rendered under separate contracts may be the basis of separate suits. Thus, an employee cannot make a partial assignment of wages that will be enforceable at law against the employer unless the latter consents to the assignment. Wow. So the single contract must sue for the entire amount. No splitting in separate contracts. Then separate suits are permissible. So wages for services already performed, the entire amount due at the time of the suit is commenced, must be sued for. So there's our partial assignment limitations there for wages. All right, so I hope you paid attention on the partial assignments, because now we're on to form and requisites in general. And before we do that, just to remind everyone, we should have the talking chat enabled here. Let me double check here and let's see if we are.
The crime says, hit the like.
Yes, indeed. All right. So there it is. You can put comments into the chat, questions, clarifications, or any other comments, and we'll be able to address them as we go along. Keep it interactive and make sure we leave no concept behind. All right. 1 second here as we continue on. There we go. Okay, we're on to the forms and requisites in general. 1 more second there. There we go. Okay. A valid assignment must contain clear evidence of the intent to transfer rights. So that intent, consent, must describe the subject matter of the assignment, must be clear and unequivocal, and must be noticed to the obligor. So the notice to the obligor of valid assignment. So let's look at this and break it down a little bit more as far as what's required. A valid assignment must contain clear evidence of the intent to transfer rights. So that's a big one right there. Clear evidence of the intent. It must, so another one, describe the subject matter. So we have evidence of intent, description of the subject matter of the assignment. So what the assignment is regarding, and must be clear and unequivocal, and must be noticed to the obligor. So here's our observation. An assignment is made when the assignor intends to assign a present right, identifies the subject matter assigned, and divests itself of control over the subject matter assigned. So instead of just a mere agency, the assignment means they divest itself control over the subject matter assigned. There must be clear intent, the subject matter described, clear and unequivocal, and notice to the obligor. All right, we're on to the section 83, the language and form. There are no formal requirements for an assignment. Any language, however informal, that indicates the intention of the owner of a claim or shows an action to transfer it. So if the owner of a claim or it's the owner of a shown action, which shows an action would be something regarding a thing intangible. So it would be something that's not where you would gain physical possession of it, but something like a claim to a debt or a stock share, something of that nature. That could be a shows an action. Otherwise, there's other claims. But the owner of that claim, and they have a valid claim in law or an equity here, to transfer, it is sufficient to vest the property in the assignee. In determining whether an assignment has occurred, the courts look to the substance rather than the form. So again, the formal language is not necessary. It's important to, of course, describe the subject matter as we saw before and make it clear. And however it's informal, it must still indicate that intention. So observation here is under the appropriate circumstances, a right may even be assigned without the execution of a formal assignment. Under the appropriate circumstances, an assignment may be in the form of an agreement or order or any other instrument. So instrument's typically a written document here that the parties may see fit to use for that purpose. So it's whatever the parties see fit. That's the form that's required for an assignment here. So it's substance over form. Courts examine intent and substance, not the particular format of the assignment. So as you see there, we don't have to worry too much about the particular forms, but the substance, making sure we covered all these points we saw here previously. Clear intent, subject matter described, clear and unequivocal, and notice the obligor. All right, let's move along here. Now let's look at the identification of the subject matter. Since we have to describe this, an assignment need only describe the subject matter with sufficient particularity to render it capable of identification. This need not be done with any greater particularity than is actually necessary with the aid of surrounding circumstances. On the other hand, an equitable assignment is precluded when the property subject to the equity is not definitely pointed out so that it may be distinguished and identified. So here's our practice tip. When an adequate description of the property assigned is included, the assignment ordinarily passes to the assignee all the rights, title, or interest of the assignor in that property. So an adequate description of the property is assigned. The assignment ordinarily passes to the assignee all the rights. So we have sufficient particularity aided by the surrounding circumstances, not perfect precision. But The equitable assignment fails if property cannot be distinguished and identified. So let's look at some of the requisites compared to contract. This will make it easy, especially for those of you that were there for the contract series we did. Assignments are governed by contract law. So an assignment is subject to the same requisites for validity as are other contracts, such as intent or mutuality of assent. Proper parties with the capacity to make a contract, consideration, and a legal subject matter. So very similar to contract requirements. In other jurisdictions, however, the requirements for an effective assignment are not the same as those for a binding contract. So let's look here. We have intent, the mutuality of assent. So mutual assent, proper parties and capacity. They have the capacity to contract. They're of majority or that capacity there. Consideration, the bargain for value. And of course, the subject matter is something legal. There's no statutory limitations to contracting in the subject matter. But there's a jurisdiction split here. Some jurisdictions hold that assignment requirements differ from standard contract requirements. I'd be curious to know what those are, but that would go beyond the scope of this presentation. Let's proceed here. Now let's look at Section 87, the writing and oral assignments. In the absence of some special contractual or statutory provision requiring an assignment to be in writing, it's not essential to the validity of an assignment that it be in writing. Thus, a valid assignment of a claim or right may be made orally. But here's our comment. Lack of formality in an assignment may mean that the assignment is revocable, or that it is subject to the defenses or claims of the obligor, which accrues subsequently, or that it can be defeated by creditors of the assignor or by subsequent assignees of the same right. However, when there is no writing to evidence an intention to transfer some identifiable property claim or right, the court may have to scrutinize the surrounding circumstances and the acts of the parties to ascertain their intentions. Under the restatement, the assignor's intent to assign may be manifested either orally or in writing unless a writing is required by a statute or by the contract. So again, the contract, and if it's a statutory or formal type of contract, then perhaps then the statute would apply there too. Some jurisdictions have determined that an assignment of another's cause of action must be in writing. So when you have that cause of action, the assignment can't be oral. I'm here to take over his cause of action. When the agreement between the original parties requires that an assignment be in writing, there is no valid assignment when there is no evidence of a written assignment. Oh, this is a good one here, huh? Or evidence that the obligor consented to the assignment. Risks of informal oral assignments may be revocable, subject to subsequently accruing defenses and claims of the obligor, defeatable by creditors of the assignor, defeatable by subsequent assignees of the same right. So writing's required when the contract requires it or statute mandates it, but oral is sufficient when there is no special statutory or contractual provision apply. But I can see oral assignments being a tricky business there. Now let's look at equitable assignments. Courts of equity can recognize certain kinds of instruments as valid equitable assignments when it is necessary to effectuate the plain intent of the parties, or when to hold otherwise would be unjust. Oh boy. To be an equitable assignment, an agreement must evidence an intent to transfer the interest, and the transferor must relinquish control over the interest. Here's our caution. An equitable assignment is imposed only through court action, and the evidence of an equitable assignment must be clear and specific. So there's two elements. There needs to be an intent to transfer plus a relinquishment of control. Then it's imposed only through court action. So those Those can be pretty tricky there too, it seems. All right, let's look at particular words in the equitable assignments. There's no particular words or particular form of instrument necessary to effect an equitable assignment. Equitable assignment. Any language, however informal, if it shows the intention of the owner to transfer it so that it will be the property of the transferee, will amount to an equitable.
Says relinquishment of an acquiescence.
To give up control altogether is what that would be. Acquiescence in when there's a duty or something like that could be. Let's see here. So no particular words or form of instrument is necessary to effect an equitable assignment. Any language, however informal, if it shows the intention of the owner to transfer it so that it will be the property of the transferee, will amount to an equitable assignment. Same principle we saw in section 84 with legal assignments. There's no magic words. Intention to transfer is the decisive factor. So kind of a breath of fresh air in the legal terminology world when they say something like this. There's no particular words, no magic words needed. It just needs to be clear to show the intent of the owner to transfer. And we're on to section 90 with the order drawn on a particular fund. An order by a creditor on his or her debtor for the payment to a third person of the whole of a particular fund or debt is an equitable assignment of that fund or debt, and after notice to the person to whom the order is directed, will bind the fund in that person's hand. Wow. Order by a creditor on his or her debtor for the payment to a third person of the whole of a particular fund or debt is an equitable assignment of that fund or debt, and after notice to the person to whom the order is directed, will bind the fund in that person's hands. A mere agreement or promise on the part of the debtor to pay claims out of a particular fund as soon as he or she receives it is not an assignment of the fund. So, mere agreement or promise to pay out claims. We saw this before. Now, here's an observation. A check does not operate as an assignment of funds on deposit. Right, so a check or a draft would be an order to pay. It wouldn't be any kind of a promise, so it doesn't operate as an assignment. It's even lower. So an order for the whole of fund would be an assignment. So the whole of the account or the fund would be an assignment. But a promise of pay from the fund is not an assignment. And a check is not an assignment. So that's an order drawn, but it's not for the entirety of it. It's not an assignment. Assignment when you have full control over the fund, meaning, of course, you'd have all the funds. All right, let's move along here. And according to the restatement, and of course, we all know what the restatements are from our fine friends over at the American Law Institute. And it all started with this fine fellow here, Samuel Williston, back in the early 1900s when he established with the first restatement, where he took those piles of files of court cases and those walls of volumes of legal and law books to be able to compile it all into a very concise restatement of the laws, the best rulings, and the way to approach the complexity of these particular laws here, especially contract law, to a point where it can be easily digestible by judges to make more prudent rulings, and also for practitioners to be able to weave through the very verbose statutes, laws, cases that all apply, but many have already been litigated to the point where the common acknowledgement of certain logic behind the cases and the reasoning stands. So that's what that's been brought to us. Just a salute to our fine friends at the American Law Institute. All right, let's move along here. So according to the restatement, a written order drawn upon an obligor and signed and delivered to another person by the obligee is an assignment if it is a conditional on the existence of a duty of the drawee to the drawer to comply with the order. And the drawer manifests an intention that a person other than the drawer is to retain on the performance. So there it is to the third person here. So that's a written order drawn upon an obligor and signed and delivered to another person by the obligee is an assignment if it is conditional on the existence of a duty of the drawee to the drawer to comply with the order. So there's a duty there. And the drawer manifests an intention that a person other than the drawer is to retain the performance. On the other hand, an order that directs the drawee to render a performance without reference to any duty of the drawee is not itself an assignment, even though the drawee is under a duty to the drawer.
Yum XK3XK says, tribe.
Hey, greetings, Yum. All right, we're doing a little tongue twister here. This one's a difficult one to get through, but we got to follow along here with the drawer and the drawee. So the drawer is, let's see here. On the other hand, the order that directs the drawee to render a performance.
XK3XK says, love you.
Likewise, and thanks for attending here. Let's move along here. Without reference to any duty of the drawee is not itself an assignment. So without reference to any duty of the drawee. So the duty here is essential. Even though the drawee is under a duty to the drawer to comply with the order, and even though the order indicates a particular account to be debited or any other fund or source from which the reimbursement is expected. So the order that directs the drawee to render a performance without reference to any duty of the drawee is not itself an assignment. So I guess here, without performance telling the person to render the payment to the drawer here, and even though the order indicates a particular account, let's see, where was it about the drawer? Even though the drawee is under a duty to the drawer to comply with the order.
Yum XK3XK says, Miles Aroni killed himself.
Gee, sorry to hear that. Well, this is quite a difficult one to wrap around, but I think if you kind of get it here, is that these kind of like promises to pay or obligations like that is not of itself an assignment, but it may work towards evidence to show intent if everyone complied, even though they didn't have a duty to. So I think that's what we're getting to. But let's just break it down to the restatement test. Is the order conditional on a duty? And does the drawer intend another to retain the performance? If yes, it's an assignment. So you've assigned the drawee to comply. And in that case, it's an assignment, so to speak. You've relinquished that that duty there. All right, let's move along. That one's been a hard one to wrap around, but now let's look at a much simpler one, the assignment by power of attorney. The assignment of a debt or of a shows in action. Remember, that's a case for an intangible like a debt or stock or something of that wouldn't be obtained by physical possession, so it's done through an action in the court, a shows in action. May be effected by means of a power of attorney to collect the money and pay it over to another person or to the creditors. So the assignment of a debt may be effected by means of a power of attorney to collect. However, the grant of a power of attorney standing alone is not the equivalent of an assignment of ownership. We saw this before with agency. A power of attorney does not enable the grantee to bring suit in his or her own name. So, as an agent with a power of attorney, the power of attorney cannot bring suit in his or her own name. Now, he could do it as agent of the principal, but it's not in his or her name, whereas the assignee could. So the power of attorney is not an assignment of ownership. The power of attorney alone does not allow suit in the grantee's own name. It must be done in the grantor's, but it would be as an agent of the grantor as that power of attorney. Acceptance by assignee, section 92. According to the restatement, a manifestation of assent by an assignee to the assignment is essential to make it effective, unless a third person gives consideration for the assignment or the assignment is irrevocable by virtue of the delivery of a writing to a third person. Wow. Thus, an assignee who has not manifested assent to an assignment may, within a reasonable time after learning of its existence and terms, render it inoperative from the beginning by a disclaimer. So, an assignee who has not manifested that assent, unless a third person gives us, so if the third person gives consideration for the assignment. Wow. So here's our practice tip. A benefited party's consent to an assignment can be manifested either expressly or by implication. So I guess you got to speak up if someone steps in and throws you under the bus. Assent's required unless, 1, the third party gave consideration, or 2, there's an irrevocable via delivery of writing to the third party. Wow. So acceptance. But there's more. The law does not require that an assignee sign a written acknowledgement. Implied acceptance of an assignment may occur when the seller knows of the assignment and accepts payments from the assignee, or when the assignee seeks performance under the assignment. So again, that's an acceptance there, de facto it seems. Implied acceptance can arise from a seller knows of the assignment and accepts payments from the assignee, or an assignee seeks performance under the assignment. All right. So there it is, the implied acceptance. And of course, section 93, the consent by obligor. Generally, the effectiveness of an assignment does not depend upon the consent of the obligor. However, partial assignments, we saw in the first section, require consent by the debtor under some circumstances. The obligor's consent is required when the rights to be assigned involve the performance of unique personal services. We saw that before with the assignments of personal skills. So the obligor's consent. You can't be substituting, someone's. You're expecting Jay-Z to perform. You can't have his brother Lazy performing and expect to be complying with the original intent. So our comment here is, although the consent of the obligor is not ordinarily necessary to make an assignment effective, the obligor's consent may preclude an objection. So if he consents, it will preclude the objection based on a change in the obligor's duty, burden, or risk in the chance of obtaining return performance. Remember, this is, although consent is not ordinarily necessary, if the obligor's consent, it may permit a separate action by partial assignee. Because their consent, if the obligor consents, could create a new contract by novation or acceptance of an offer of novation, and may thus terminate the assignor's power to revoke a gratuitous assignment. And of course, obligor's consent may discharge or modify a duty of the assignor or a condition of the right assigned. So be careful what you consent to. And we have more. Come on. Didn't do it. Here we go. So we have, according to the restatement again, of course, from our fine friends over at the American Law Institute. According to the restatement, an obligor's consent to an assignment is irrevocable when it is made before the assignment or when a material change of position has taken place in reliance on the obligor's consent. So you have the irrevocable consent is consent given before the assignment, or 2, material change of position in reliance. All right. Now we're on to the form and requisites in the consideration. So we see some of these contractual terms here. Let's look at section 94. A valuable consideration is essential to support an assignment. However, it has been held that a lack of consideration does not render an assignment invalid, and that a valid assignment may be the product of either a gift or contract. So you have these gratuitous assignments. In other jurisdictions here, although an assignment normally requires consideration, an assignment is valid even though it is made without consideration when there has been a delivery, or when the assignment is in writing. This is the position essentially stated by the restatement. So that's our observation there. A valuable consideration is essential, but lack to support an assignment, but lack does not render it invalid. So take that as you will. Here's our practice tip. The consideration for an assignment need not appear on its face, but may be proved by parole evidence. So you could go there and talk about the consideration there, inferred from the agreement or implied. So it doesn't have to be necessarily written in black and white. Validity without consideration. It could be gift plus delivery or gift plus writing. And that's our restatement position. So that donative intent in writing really helps. All right. So let's at section 95 here. What constitutes a valid consideration, especially regarding assignments? Items which constitute valid consideration to support an assignment when such consideration is required include a promise to release the assignor from all the claims that the assignee had at the time against the assignor, an assignee's promise to take the assignor back to court to seek enforcement of the assignor's property settlement against the assignor did not assign pension benefits. A title ensures conditional release of its negligence and breach of contract claims against a mortgage broker for selling a mortgage without first clearing earlier mortgages. So look at these considerations here. All value bargain. The satisfaction of a contractor's obligation under an indemnity agreement to deposit collateral with a surety. And the transfer of a predecessor's company's assets to a newly organized successor company in exchange for 100 shares of stock in the successor's corporation. So these are items which constitute valid consideration to support an assignment. Those are just some of them when it's required again. So let's look at lack of consideration as a defense. So the original debtor may not raise the defense that an assignment was made without consideration when sued by the assignee. The assignee may generally recover an action against the original debtor or obligor, even though there was no consideration for the transfer between the assignor and the assignee. Now, although consideration is necessary as between an assignor and an assignee, as between an assignee who has acquired legal title to the shows and the obligee in the shows, consideration is unnecessary. Debtor cannot raise this defense. Lack of consideration between assignor and assignee is irrelevant when the debtor is sued. So, although consideration is necessary as between an assignor and assignee, as between an assignee who has acquired legal title to the shows. What's the shows is the thing. And we talk about the legal title, and that's the...
Young XK3XK says, I miss you.
Well, here's where we've been, shredding away at the good stuff here on this channel here. Right now, we're just finishing up agents assignments, which we'll have one more episode on this, and now round that up for American jurisprudence on assignments. And that also is used to culminate our whole series we've been doing here on contracts, property, agency, and assignments. All right, let's see here. So the lack of consideration as a defense here between the assignor and assignee is going to be a defense that can't be raised by a debtor, because that particular obligation in the shows here, in the obligee in the shows, that consideration is unnecessary. That's between the parties there. As long as they could sue between each other, assignor and assignee, regarding consideration, but not necessarily the debtor. Consideration is unnecessary. Let's move along here. Observation. The inadequacy of consideration standing alone is insufficient to vitiate an assignment between the parties to it. A voluntary written assignment is revocable once the instrument is signed and delivered. It is irrevocable once it's signed and delivered, the instrument, and thus cannot later be set aside by the assignor for lack of consideration. So once it's signed and sealed, that's acceptance for value. So signed and delivered is irrevocable. It cannot be set aside for lack of consideration after the fact. That's if it's signed, sealed, supposedly according to statutes, and delivered. So that's what makes it irrevocable. But without these, then that is disputable. So let's look at the form requisite, delivery or transfer. So here we get generally section 97. In every transfer of title from one person to another, there must be an actual or constructive delivery of the thing or of paper title with intention to pass title, and an actual or constructive acceptance. What's constructive delivery or constructive acceptance? That would be through, of course, that could be through a court. But the actual or constructive. So actual would be the standard way of doing things. Constructive would be because of some other overlying duty, obligation, ruling, control of the thing. And of course, we know the thing is the subject matter of a right or interest. That's what they mean by thing. So the thing or of paper title. So the thing is the subject matter. This is the thing can be taken possession of, but physically, but paper title would have to be done through an action, a shows in action, with intention to pass title, and an actual or constructive acceptance. So again, the acceptance would either have to be through a court action, it could be the results of that, or an actual acceptance. Mutual assent, a manifestation of mutual assent would be the acceptance. So here's how we can do the delivery or transfer. Actual or constructive delivery. Any way a reasonable person would expect you to have accepted it would be constructive delivery. Intention to pass title. Okay, and of course the actual or constructive acceptance. So we need to have some evidence of that manifestation of mutual assent. All right, so now we have section 98, complete and present transfer. To be effective, an assignment must be completed with a delivery, and the delivery must confer a complete and present right on the transferee. Complete and present right. The assignor must not retain control over the property assigned, the authority to collect, or the power to revoke. Irrevocable once it's been assigned. An order or agreement that contemplates a further act to contemplate the transfer does not affect the assignment. An order or agreement that contemplates a further act, for example, an express statement in a contract that a party shall assign its liability in the future, only sets the stage for assignment. It does not operate as one. Here's our comment. A present assignment may be coupled with a promise to provide future evidence of the transfer, but there is no assignment if the transfer is not to take place until the obligee acts further. So until the act is done, the present transfer, there it is. So the assignment's not complete without that present transfer. The assignor must not retain any control over the fund, any authority to collect it, or any power of revocation. So they can't revoke it, they can't draw from it, nothing. The assignor must not retain control over the property, authority to collect, or power of revocation. All right, let's see here. All right, now we're on to the intent to assign. Generally, whether an assignment of contracts has occurred is determined by the intent of the parties. The assignor must intend to transfer a present interest on the subject matter of the contract. According to the restatement, it is essential to an assignment of a right that the obligee manifest an intention to transfer the right to another person without further action or manifestation of intention by the obligee. In the absence of an applicable statute, the assignor's manifestation of a present intent to assign does not have to be in writing. So the manifestation can be oral, huh? In fact, when there's a manifestation of the assignor's intent to assign, the assignment may be made without any particular formalities or with informal language. So I guess the implication's enough in that case. All right, here's our cases. Speaking of cases, the contractual rights are assigned when the assignor manifests the intent to make the assignment. So that's the timing. Intent is of paramount. The present interest plus the manifestation of intent equals assignment. No special formalities required. Now look how easy that is. Present interest. Remember, it's not the future interest, not a promise in the future, but the present interest. Contract rights are assigned when the assignor manifests the intent, manifestation of intent, to make the assignment. That starts the assignment. No special formalities required. Simple formula there. Let's move along. Now we have section 100, the evidence of intent. We talk about manifestation of intent, how we evidence that. The intent to assign may appear from the writing itself, or it may be derived from another source, such as the acts of the assignor or the surrounding circumstances. So remember, taking payments, things like that. In determining the intent of the parties to an assignment, all the facts and circumstances surrounding the transaction must be taken into consideration. So the totality of the situation. Practice tip. Although it's not necessary to use a particular set of words or form to create an assignment, the court may cite the use of traditional language of an assignment in an instrument as indicating the party's intention to effect an assignment. So, although that special magic words isn't required, there are some magic words that courts like. And of course, we can always find those magic words typically from our fine friends at the American Law Institute and the restatements. The intent of the parties to an assignment is a question of fact. So the sources of intent are the writing itself, the acts of the assignor, the surrounding circumstances. These are a question of fact for the finders of fact. All right, now we're on to filing, recording, and notice. Generally, in the absence of a statute, it's not necessary to file or record an assignment of a shows of action, inaction, or a contract right. So it's not necessary to file or record an assignment of the shows in action. Here's our observation though. Ordinarily, the recording statutes are inapplicable to assignments. However, in some jurisdictions, certain kinds of assignments, such as those of mortgages, conveyance of real property, assignments of rents and profits, or the transfer of a judgment or cause of action, must be recorded in order to render them valid against the claims of third parties. So the cause of action is still there, but to record them according to statutes, recording statutes would this is the way to render them valid against claims of third parties here. So caution, filing a notice of an assignment of a judgment in the real estate records does not constitute notice to subsequent encumbrances and purchasers of the real estate. Let's see, does constitute, notice to subsequent encumbrance, I was going to say. So filing a notice of an assignment of a judgment in the real estate records does constitute notice to subsequent encumbrances and purchasers of the real estate, but does not constitute notice to the judgment debtor so as to require the debtor to pay the assignee rather than the assignor. So notice to pay a different party here. So filing the notice. All right, interesting there. Let's move along to the sufficiency of a notice to the debtor. No special forms of notice of an assignment to the obligor is required. Any notice is adequate, although not formally given, if it reaches the person to be notified in such a manner and under such circumstances that a reasonable person would regard it as notice and be guided accordingly. Here's our observation. Notice of an assignment is effective when the debtor receives notice that the funds have been assigned and payment is to be made to the assignee. All right, let's look at the sufficiency of notice to the debtor. Under the Uniform Commercial Credit Code, Uniform Consumer Credit Code, I apologize. Under the Uniform Consumer Credit Code, notice of an assignment is not effective unless it reasonably identifies the assigned rights. The Uniform Consumer Credit Code and Restatement Second Contracts provides some protection to an obligor who receives insufficient notice of an assignment or has notice of a claim to the debtor's funds or performance that it is adverse to that of the assignee. The reasonable person standard here. No formal notice required, only that a reasonable person would regard it as notice and act accordingly. All right. Now we're on to the imputed constructive or inquiry notice, section 103. Even though the debtor has no actual knowledge of an assignment, if he or she has knowledge of such facts as would put a reasonable person upon inquiry, as would indicate heedless disregard of others' rights if no attention were paid to them, the effect is the same as if actual notice had been given. Here's your constructive notice. However, a notice of assignment under the Uniform Commercial Code cannot be established.
Miss Linsky 11 says, saving so I can watch later in bed.
Excellent. Yep, we got almost done here. And then for those that stayed to the end, we do have a very special surprise here at the end. So you may want to stay if you can. Other than that, it'll still be here, but we get to participate, and that's the special part about it. So let's continue here with section 103. If an assignment is under the Uniform Commercial Code, notice of an assignment cannot be established through constructive notice. So if it's under an assignment under the UCC, the Uniform Commercial Code, not the Uniform Consumer Credit. What was this thing? Gosh. A little more back. Wow, it's that far back, huh? Yeah, where did it go? All right, well, I'm getting too far off track here. Let's say uniform. All right, never mind. Yeah, all right. We've gone too far out of here. Let's see here. Trying to get back to where we were. All right, so we had the cautions here. Here's our observations of sufficiency. No special form. Any notice is adequate. So the reasonable person standard. And now we're on to Uniform Consumer Credit Code. That's what it is. All right. So, the caution, if the obligor has knowledge of facts sufficient to put him or her on inquiry about an assignment, he or she is not entitled to rely only on the statements made by the assignor. So he can find out for himself. Do your research. The doctrine of presumptive Presumptive or imputed notice is resorted to with reluctance and generally invoked only when it would be unconscionable to permit the defendant to assert that he or she had no knowledge, so you can't play dumb. Inquiry notice equals actual notice, but the UCC does not recognize constructive notice for assignment, so it has to be actual notice for UCC, and that's typically with regulating goods. So here's section 104 between the assignee and debtor, with the effect of notice to the debtor. A debtor has the right to deal with his or her creditor until he or she has actual notice of an assignment of the debt. A notice of assignment, however, charges the debtor with the duty to pay the assignee and not the assignor. An assignment of a shows in action is not complete so as to vest title absolutely in the assignee and to charge the debtor with the duty to pay the assignee until notice of the assignment has been given to the debtor. The assignment is incomplete, not only as regards to the debtor, but also to third persons, including subsequent assignees and attaching creditors. So that makes it difficult as title changes hands. So caution here, although one court has held that an obligor need not show prejudice from the lack of notice of an assignment in order to defeat the claim of an assignee, another has held that lack of notice makes an assignment ineffective only where there is a contest between the assignee who has failed to give notice and the obligor and third parties claiming to have derived rights from the obligor prior to the notice, and there is no prejudice to the obligor. So that's where it all comes down, prejudice to the obligor. For most jurisdictions. All right, so section 105, payment before notice, because the notice of the debtor of the assignment is necessary in order to charge the debtor with a duty of payment to the assignee. The debtor will be discharged if, before receiving notice of the assignment, he or she pays the assignor or the assignor's judgment creditor or subsequent assignee. So again, timing, payment before notice. According to the restatement, notwithstanding an assignment, the assignor generally retains his or her power to discharge or modify the duty of the obligor to the extent that the obligor performs or otherwise gives value until, but not after, the obligor receives notification that the right has been assigned and that the performance is to be rendered to the assignee. But under the Uniform Consumer Credit Code, a consumer may pay the original creditor until he or she receives notice that there has been an assignment and that he or she must pay the assignee. While it is true that there is no limitation of time for the notice of an assignment to be given to an account debtor, an assignee who chooses to delay in doing so clearly assumes the risk that the account debtor will continue to pay the assignor. So the assignee has to give notice here, it looks like. If you want to get paid. Otherwise, pre-notice payment to assignor means the debtor is discharged. So pre-notice payment would discharge the payments when it's assigned. The assignee bears the risk of delayed notice. So it had been transferred over to the assignee or assigned to the assignee, transferred, whatever, but the debtor or has been paying the assignor. The debtor's discharged from that if they don't give him notice. And then the assignee is going to have to go to the assignor and get his funds. Good luck. Section 106. Continued here. After notice of an assignment has been given to the obligor, the assignor has no remaining power of defense of release. Power of release. Thus, if a notice of the assignment has been given to the obligor, he or she must pay the assignee and remains liable to the assignee if he or she pays the assignor instead once notice. On the other hand, if the obligor pays the assignee after notice, even if there's a defect in the right of the assignee has the same power as the assignor had to discharge or modify the duty of the obligor to the extent that the obligor gives value or otherwise changes his or her position in good faith and without the knowledge or reason to know of the defect. So, even if it was an invalid assignment. A practice tip here. An account debtor who pays the assignor after being instructed to pay the assignee is not precluded from raising any defenses and claims arising from the contract with the assignor in an action for wrongful payment by the assignee. So we gotta pay attention to that stuff. So let's look at the caution here. If an account debtor continues to pay the assignor after receiving notice and the assignee does not object, the account debtor is not bound by the assignment, and an assignee who wants to take over collection must notify the account debtor to make future payments to him or her. Wow, so under the Uniform Consumer Credit Code, this is an interesting one to look up here. If the consumer requests further information after receiving a notice of an assignment, the assignee must furnish the consumer with reasonable proof that the assignment has been made, and until the assignee does so, the consumer may safely pay the assignor. Before notice, payment to assignor equals discharge. After notice, payment to the assignor, you pay the assignor, but you're still liable to assignee. So notice is essential. Now let's look at section 107. Between the assignor and the assignee. As between the assignor and the assignee, and the assignor's creditors, or those who merely succeed to the rights of the assignor. Notice of the assignment to the debtor or holder of the fund is not a prerequisite to the protection of the assignee. Notice to the debtors or to the creditors of the assignor is not essential to complete the assignment. So here's our caution. Help make this make sense. Even though an assignment may be effective as between parties, it may still be ineffective as against the obligor. To be effective against the obligor, notice of an assignment must clearly express to him or her that a right has been assigned. So, between the assignor and assignee, notice is not required, but against an obligor, notice is required. It must be clearly expressed about the assignment. So, yeah, you might have assigned someone, but you can't keep it a secret if there's other people that are obligated. All right, so this takes us to the best part, the fun quiz, where we get to test our knowledge. So let's get to it. For those of you who stayed for the special treat, I'll tell you how this works. In the chat, you put in the number of the question you're going to answer. You select one of the answers here, and you put it in after the question number. So, for instance, for question 1, I put in the chat. If I was selecting answer D, I put in the chat Arabic number 1 followed by letter D delta, and that would be my choice. If I choose to change my choice, I would just put that same question number again, followed by my changed choice, and that would be my final answer. Tally up at the end, test our knowledge. Let's get started. So, question 1. Dan owes Carla $10,000. Carla assigns $4,000 of that debt to Alex without Dan's knowledge or consent. Dan later learns of the partial assignment. Which of the following is true? So Dan's a big daddy warbucks here. He's got the 10 grand. Oh, sorry. Wait. Dan owes Carla 10 grand. I'm sorry. Carla's the one with the big bucks here, and Dan owes her 10,000. But Carla assigns 4,000 of that to Alex, but she didn't tell Dan that. So he only owes Carla 6,000, and now he owes Alex 4,000 of that original 10,000. But she did it without Dan's knowledge or consent. Dan later learns of the partial assignment, which is true. A, Dan must immediately pay Alex 4,000 and Carla 6,000 in separate payments. B, the partial assignment is automatically void because Dan did not consent. C, Dan's right to defend against Alex as a partial assignee is not affected by notice of the partial assignment. Or D, Alex may only recover $4,000 if Carla joins as a co-plaintiff and Dan has no right to object. All right, so again, Dan's the one that borrowed money. He borrowed 10 grand. But Carla decides that she wants to assign $4,000 of that to Alex. So which is following true? She didn't tell Dan, the one that owes her the money, that she assigned part of that.
Pre G5E says we left off on section 72 yesterday, and I showed up at section 99 today. This treat at the end will not be easy for me.
We didn't skip anything though because I actually went over the federal contracts. I don't think too many people in the audience or subscribers to the channel are dealing with those huge federal contracts, and it got to be it was just not, it would be not entertaining at all. And there's no fun quiz to extract out of that. If you're making that kind of money on federal contracts, and that, salute to you. Nonetheless, I figured it just wasn't in character with the rest of these assignments here for the rest of us in private business or even quasi. Okay, so let's continue on here. So yeah, you didn't miss anything. This has been a complicated one here on the assignments here because we're looking at the form and requisites. But as we see here that the form is less important than the substance, and the requisites are based on many of the similar terms and requirements as contracts. All right. So again, Dan owes Carla 10 grand. What's the outcome here when she assigns 4,000 of it to Alex without telling Dan? Does Dan now have to pay Alex and Carla separately? Is a partial assignment void because he didn't consent? Does Dan have the right to defend against Alex as a partial assignee, not affected by the notice of partial assignment? Or can Alex only recover 4,000 if Carla joins as a co-plaintiff and Dan has no right to object? So complicated one here. Of course, go ahead and take a guess because at the end we go over the answers and explain why the answer is correct and why the others aren't. Any takers for question 1? Going once. Going twice.
Per G5E says 1C. Joseph figure 5,227 says 1B.
Okay, so we got a couple answers here, a B and a C. Anyone else wants to take a try at question 1? If not, we're moving along to question 2. Okay, question 2.
Audit term says 1B.
All right, so we have a couple for B and one for C. So question 2. Priya verbally tells her friend Sam, I'm giving you my right to collect the $5,000 that Riviera Corporation owes me. No document signed. Oh, what a good friend. Under the general common law rules governing assignments, which statement is most accurate? A, the assignment's invalid because all assignments must be evidenced by a writing to be enforceable. B, the oral assignment may be valid, but it carries risks such as being revocable or defeatable by the assignor's creditors. C, the assignment is valid and fully enforceable in all respects identical to a written assignment. Or D, the assignment is void unless Riviera Corp consents to the oral transfer. So Riviera Corp owes Priya, and she tells her friend Sam, I'm giving, so this is a gift. I'm giving you my right to collect. So we can think consideration here is a gift that may not be necessary.
Per G5E says 2B.
All right, we got a 2B. Anyone else wants to take a stab at question 2? Think consideration, think gift.
Audit term says 2B.
All right, you got a couple for 2B. Any other takers for question 2? Question 2 going once, going twice. We're on to question 3. Marcus assigns his contractual right to receive payment from Lee to a third party, Nora. However, Marcus continues to collect payments from Lee himself and retains authority to modify the debt as a valid assignment occurred. A, yes, the assignment is valid as long as Marcus expressed intent, regardless of the retained control. B, no, a valid assignment requires the assignor not retain control of the property, authority to collect, or power of revocation. C, yes, but only if the assignment was made in writing and Lee consented. Or D, no, because Lee was never given notice of the assignment, it cannot take effect. So, Marcus assigns his right to receive payment from Lee. He assigns that to Nora, so now Lee's supposed to pay Nora. However, Marcus continues to accept payments from Lee himself, and he retains authority to modify it. Is a valid assignment really occurred to Nora. All right, anyone want to take a...
Audit them says 3C.
All right, so we get a C. Yes, but only if the assignment was made in writing and Lee consented. All right, any other takers for question 3? These are all difficult, so when you have a heart of glass here, these are all going to be, there's no easy ones here tonight. All right, we're going on to question 4 here.
Pre G5E says 3B.
All right, so we get 3B and a 3C. All right, we're getting some good variety here. That's good. Let's move along here to question 4. Taylor assigns a debt owed by Jordan. So Jordan owes a debt to Taylor. She assigns a debt to a new party, Casey, but neither Taylor nor Casey notifies Jordan. Jordan pays Taylor in full, unaware of the assignment. Can Casey still collect from Jordan? Oh man, double jeopardy here. A, yes, the assignment is vested full title in Casey at the moment of assignment, so Jordan's payment to Taylor is irrelevant. B, yes, but only if Casey can prove that Jordan had constructive notice through publicly available records. C, no, because Jordan paid Taylor before receiving notice of the assignment, Jordan is discharged from the debt. Or D, no, because Taylor failed to obtain Jordan's consent. The assignment was never valid. Okay, so we get a tricky one here for question 4. Taylor assigns the debt to Casey. Jordan owes her money, but nobody notifies Jordan, and Jordan keeps paying Taylor, the obligee, the assignor, I should say here, because she hasn't assigned it.
Pre G5E says 4D.
All right, so we got a 4D here. No, because Taylor failed to obtain Jordan's consent, so the assignment was never valid. Any other takers for question 4 here? We have some pretty good answers here. There's only one in here that really doesn't seem reasonable. But could it be that the assignment vested full title at the moment of assignment? Let's look at this here. Taylor assigns a debt. No one notifies Jordan. So we don't have constructive or actual, it seems. Jordan pays unaware of the assignment. So, any other takers for question 4? We're going to move along to the answers. Going once, going twice, going 3 times. All right, we're on to the answers. So, for question 1, Dan owes Carla $10,000. Carla assigns that $4,000 to Alex without Dan's knowledge. Dan later learns of the partial assignment, but which of those is true is C. Dan's right to defend against Alex as a partial assignee is not effective.
Says 4D.
Okay, so we have a 4D in there. All right, a little late there, but we were good to go here. So, on question 1, we have Dan's right. The correct answer is C, because Dan's right to, we got a correct answer there. Excellent. Dan's right to defend against Alex as a partial assignee is not affected by notice of the partial assignment. So under Section 79, the debtor's defenses against a partial assignee survive, regardless of whether the debtor received notice of the partial assignment. So his right to defend is not affected by notice. So there we go. No knowledge or consent, but his right to defend against Alex as a partial assignee is not affected. All right, let's go on to question 2. Priya verbally tells her friend Sam, I'm giving you the right to collect the $5,000 that Riviera Corp owes me. Nothing signed. The general common law rule governing assignments, which is most accurate, and it's B. The oral assignment may be valid, but it carries risks, such as being revocable or defeatable. So this is the trick here, is that with these types of things, and I think we all get this one right. Excellent. Greg got that one. Audit them. Indeed. B is correct because per Section 87, oral assignments are generally valid, absent a contrary statute or contract. But informality may render them revocable, subject to obligor defenses, or defeatable by creditors or subsequent assignees. So if other assignees are like, well, that last one was just verbal, there's no evidence of it, and I have a written assignment. So there you go. It may be valid, but it carries risks. All right, we're on to question 3. Marcus assigns his contract rights to receive payment from Lee to Nora, but Marcus continues to collect payments from Lee and retains authority to modify the debt. Has a valid assignment occurred? The correct answer is no. So the correct answer for 3 is B, no. I think I them get that one correct. Excellent. Yep, I think we all are pretty much on track with that one because no valid assignment requires the assignor. A valid assignment requires the assignor not retain control, authority to collect, or power of revocation. Section 98 mandates that the assignor must divest all control, collection authority, and revocation power. Marcus's retention of these powers prevents a complete and present transfer. So it was no valid assignment. All right, we're on to question 4. Last and final one, and the correct answer for 4 was actually C. The tricky one here. Taylor assigns the debt owed by Jordan to a new party, Casey, but nobody notifies Jordan. Jordan pays Taylor in full, unaware of the assignment. Can Casey still collect from Jordan? Correct answer is C, no, because Jordan paid Taylor before receiving notice of the assignment. Even if it was constructive, Jordan's discharged from the debt. Under Section 105, a debtor who pays the assignor before receiving notice of the assignment is discharged. The assignee bears the risk of delayed notification. So it looks like Casey's going to have to take it up with Taylor because Taylor's holding that money, and Jordan is discharged. So there it is. That was an excellent. Where we go here? That's an excellent section here that we've gone over here with assignments. Covered a lot here. Section 79 to 107 is actually, I think, what we covered. And that brings us to the end of the presentation. So for those of you that have stuck it out through the end, salute to you. This has been a rigorous one. The final one we're going to be doing is when we look at the actions, and that's going to go really fast. That's where the rubber meets the road when it comes to this. And it'll be the culmination of all this knowledge and to see how it actually happens in practice and a lot of practical applications. With that said, I thank you all for attending, and I hope to see you all on the next one. Peace out.
The tribe says, hit the like. Craig Curry G5E says need to watch again. Those were guesses and I want to know. The tribe says, this was a complicated I'm for sure.